Welcome back to Order in the Court with Khalif and Brian. Another topic we're going to be talking about is Etan Patz. This is the young boy that was first featured on the milk carton back in 1979. He disappeared on his way to school while walking to a New York City school bus. It was a cold case for a long time, but finally there was a conviction, and then it was tossed out by an appeals court. So let's talk about this reinstated murder conviction that was done by the Supreme Court here recently.
Well, let's look at a couple things. Alvin Bragg is the Manhattan District Attorney. That name, if it sounds familiar to you, it should. He's the individual that brought a case against now President Trump and has been out there doing a number of these types of cases. He talks about this case in saying that he disagreed with the second the Second Circuit's ruling, calling it a slender read that ignored the evidence presented during a 5-month trial involving 66 witnesses. So before I dig into that, I'll say this decision by the Supreme Court, right, that was a long party line, 6-3. It grants an appeal from the New York prosecutors, Alvin Bragg and his team, and it's not talking about innocence or guilt. This is more saying, does a federal court, that's that circuit court, do they have the ability to require that a state court conviction be overturned? Was there a violation or an overstepping of that federal court's authority? And that's really what they ruled on. They didn't really rule on the facts or the merits of the case. That's why Alvin Bragg and his team said, hey, we have to wait a decision from the other courts to figure out how we move forward with this case. Because remember, 2015, he was first tried and it was ended in a hung jury. 2017, a second jury convicted him. And the issue at that case is what the Second Circuit had to deal with when looking at this with
Miranda
the Court of
rights.
Appeals. Right. Miranda rights in questioning. So whenever I've ever sat in a trial, either when I clerk for a judge or when I have had trials myself, I love jury notes and I hate them all at the same time. When a note is given from the jury, they're already deliberating, and this is the first time they're able to have conversations with one another, and this is the first time that they can start looking at the evidence and start, talking amongst each other, and reviewing their notes and having conversations about, okay, how do you feel? Whenever there's a note sent, we're not in the courtroom. We're somewhere else. The deputies will come, the bailiff will come and say, hey, there's a note. And your heart sinks, and it's like, oh man, is it a verdict, right?
Mm-hmm.
And they'll let you know it's not a verdict, but the judge is going to address it. All right. So the judges, they'll bring you out, and the judge will say, hey, I don't have a verdict, but I have a question. So if there's video or if there's audio, I won't say that I love these type of notes, because most of the time the jury's going to want to say, hey, can we get the video back in the jury room? And most of the time the judge is going to say, no. We're going to have to watch it back in here, and we're going to have to watch it in its entirety. So if we just watch a 3-hour video, we're going to be watching that all over again right in here if they have questions, even if it's about 1 second of the video. The other thing is if they have questions about the law. The judge is the person that just gives them the law, gives them instructions on law. So in this case, the question was that they wanted to know a couple of things. They asked whether if they could conclude Hernandez's initial confession was involuntary because he had not yet been advised of his rights. They were required to disregard his later confessions as well. The trial court judge simply responded, the answer is no. The Court of Appeals held that, and that Second Circuit says that his answer was inadequate and that jurors should have received a more detailed explanation, including the possibility that they could choose to discount all of Hernandez's confessions. And so if the judge gives an improper statement of the law or doesn't give full
which he confessed.
understanding,
Yes.
if the judge doesn't give you, because remember, the judge is required to give you the law. If they don't give you a clear understanding of the law, now the judge could say, hey, I've given you the panel jury instructions. Go ahead and go back and read the jury instructions. Or if they say, hey, give me a definition of what this is saying, go back and look at the jury instructions. I've had judges do that. But to this question, if there is an option for one way or the other, and you just say no, then now you've done a misjustice to this individual. And because of that, that's why his team appealed, and that's why they were successful on the appeal. I can tell you that this is one that I think once it ultimately goes back, it will have problems with the confession, with the Miranda. I mean, the thing that jumps off the page to me is that they held him for 7 hours.
Mhm.
They allowed him to wait and sit,
Police
go back
questioning
and
for
forth.
7 hours.
7 hours.
Not read his Miranda rights, which is the 1966 Supreme Court decision, Miranda versus Arizona,
Yep,
in
yep,
which you
yep,
have to remain silent
yep.
if you or to have an attorney present. You have to have read that. Police officers provided Hernandez with that Miranda warning,
Yep. Yep.
but he confessed again. But the confessions that prosecutors say used at Hernandez's trial.
And the other thing is that his team is arguing that he had some type of mental illness that stopped him from understanding and appreciating what they read to him. And so even if they did read the Miranda rights to him, that he would not have understood what was happening. And so I think because of that, it at least opens the door for, and you can see why the 2015 jury was hung. Because if that information was presented at trial, you could assure that a person would say, okay, this person that didn't receive Miranda rights at first and then was given to him at second, and it doesn't have the ability to understand what was even happening during any of these interactions, how could they then go forward and do some recorded statement twice admitting to doing this? And so those are the types of things that ultimately could come back if it goes to trial again. So yes, this was definitely a one that jumped off the page. You asked, do I remember this? I for sure do remember seeing the milk cartons with him
Etan
on,
Patz?
yeah, with Pates on the milk
When
carton.
do you think this goes to trial again?
I mean, first you got to get it back. I mean, the Supreme Court has ruled that the Second Circuit overstepped its authority, right, by saying that the trial court judge in the 2017 case misinterpreted the law. And so the first thing I'd say is that they may kick it back and say, all right, a court of appeals, we're not going to touch this. That doesn't mean the case is over. That now means his team could appeal it to another circuit on the state level, as opposed to where they went on this federal side. Not sure why they went that way, what strategy would have occurred for them to make that decision, but they decided to go there. Our Supreme Court, United States Supreme Court, said that federal court did not have the authority to make that decision.
Queen City News Plus. Just search Queen City News on your smart TV's app store.